Embezzlement is the fraudulent conversion of someone else's property already in the defendant's possession. The defendant already had possession but not ownership of control of the property, and the defendant used property for their own uses. Computer crime refers to federal statutes that prohibit unauthorized access to computers in the federal government, at financial institutions, and by means of an internet that crosses state lines. Federal prosecutors have sharply increased the number of people they charge with money laundering. Is this because more and more people are funneling drug money out of the country? Not necessarily. Defense lawyers say that prosecutors are now routinely adding on money laundering charges to cases that used to be routine fraud cases. For example, a medical supply company bills the federal government for prosthetic devices that it never delivered. Formerly, that would have been a simple Medicare fraud case. Today, though, it's likely to be a Medicare fraud case and money laundering case. Prosecutors in such a case argue that the money obtained illegally from the federal government is used to invest in and maintain a legitimate business, and that's money laundering. If the medical supply company uses money obtained from fraudulent bills to pay the rent on its company headquarters, it's laundered the money. So you may be wondering, what's the big deal here? Why is it a big issue to tack on money laundering? Time in prison. A simple fraud conviction typically results in a sentence of 5 years or less. A money laundering conviction can increase the penalty up to 20 years in prison. In addition, a prosecutor who tacks on a money laundering charge puts extra pressure on the defendant to plea bargain because the penalty for a conviction could be so high. Defense lawyers claim that this practice is unethical, and that Congress intended stiff money laundering penalties for big-time drug dealers who gravely damage our country by importing harmful substances. A small business dealer who cheats once or twice should not be treated like a drug kingpin. Prosecutors respond that they are ethically required to charge the most serious provable crime, and that Congress wrote the money laundering statute broadly in order to discourage all fraud, not just drug-related offenses. The Computer Fraud and Abuse Act prohibits using a computer to commit theft, espionage, trespass, fraud, and damage to another computer. The Access Device Fraud Act outlaws the misuse of cards, codes, and account numbers. The Identity Theft and Assumptions Deterrence Act bars the use of false identification to commit fraud or other crimes. The Wire and Electronic Communications Interception Act makes it a crime to intercept most wire, oral, and electronic communications. If someone commits a crime within the scope of his employment and to the benefit of the corporation, the company is liable. The punishment for this can be fines, which are appropriate since this hurts the profit, and sometimes imprisonment. By imprisonment, this usually includes closing down the company temporarily or permanently. Compliance programs refer to if a company has a valid, functioning plan to prevent and detect criminal behavior. The judge must, according to federal sentencing guidelines, reduce the penalty of a crime of an employee. The Occupational Safety and Health Act, or OSHA, sets standards for safety in the workplace. A state, however, may decide to set standards tougher than OSHA. The Racketeer Influenced and Corrupt Organization Act creates both civil and criminal law liabilities. It's aimed at organized crime, those people involved with a series of illegal acts. Money laundering means using the profits of criminal acts to promote more crime or concealing an illegal source of money. This is commonly associated with illegal drug trade. RICO, or the Racketeer Influence and Corrupt Organization Act, prohibits using 2 or more racketeering acts to accomplish certain goals. Racketeering acts include, among others, embezzlement, arson, mail fraud, and wire fraud. To violate RICO, there must be 2 or more of these acts. Goals that violate RICO include using criminal money to invest in or acquire a business, maintaining a business using criminal activity, or operating a business using criminal activity. No matter what crime a suspect is accused of, the Constitution of the United States offers protection against inhumane treatment and ensures certain human rights. The procedures by which a suspect is investigated, arrested, interrogated, and tried is controlled by the Bill of Rights. Almost all important criminal procedure rights have been expanded beyond the federal government to law enforcement at the state and local level. Notification to the police is when the police find out about a suspect, sometimes by an informant. If a search is needed, then the police need a warrant. Police take an affidavit, which is a sworn written statement from an informant, and they take this to a judge who issues the warrant, giving permission to search a particular place, looking for particular evidence. Probable cause means that based on the information given, it's likely that the specified evidence will be found. Search and seizure is when police may search and seize only what is specified by the warrant. Based on information found in the search, a judge may issue an arrest warrant. When a suspect is arrested, he is informed of his rights and booked. This means that his name, photograph, and fingerprints are recorded along with the charges. A bail hearing is when a judge must promptly decide what the bail, if any, will be. This is the amount that must be paid for the suspect to be set free pending trial. If a grand jury, who are ordinary citizens, determine that there is probable cause to proceed to trial, the suspect is indicted or charged with the crime. Arraignment is when the indictment is read to the suspect, who then pleads guilty or not guilty to the charges. Discovery refers to when both sides gather as much evidence as possible. The prosecution must hand over to the defense any evidence favorable to the defense. If the defense thinks that the prosecution got evidence illegally, it will ask the judge to exclude that evidence. This is called a motion to suppress. In many cases, the prosecution will offer to end the case with reduced charges if the defendant will plead guilty. This is referred to as plea bargaining. Trial and appeal means that if no plea bargain is reached, the case goes to trial. The prosecution must convince the jury beyond a reasonable doubt in order to convict. Convicted defendants may appeal. The Fourth Amendment prohibits illegal searches and seizures. There are 6 situations in which police may search without a warrant. If the evidence is not concealed but is in plain view, the police may search a subject if there's good reason to believe he may be armed. This is called stop and frisk. If there's an emergency situation, such as a chase, the subject may be searched. If lawfully stopped for other reasons and evidence is visible, police may search an entire car. Anyone arrested may be searched under lawful arrest. Lastly, if consent is given by the lawful occupant of the home, police may search it. A search with a warrant is still unlawful if there's no probable cause, or the warrant did not specify place or items, or if it extended beyond the scope of the warrant. Exclusionary rules means that evidence obtained illegally without a warrant or improperly obtained with a warrant may not be used at trial against the victim of the search. The purpose of the exclusionary rule is to make sure that the police follow proper procedures. The Sixth Amendment guarantees the right to a lawyer and to have one present throughout every stage of the process. The government must provide a lawyer at no charge if someone can't afford one. The Eighth Amendment prohibits cruel and unusual punishment. Capital punishment has been very controversial under this amendment. The Three Strikes Law is also controversial because it creates situations where a punishment is excessive for the crime. Forfeiture, or forced loss of property, has been allowed under this amendment, but the allowable amount has not been set. Congratulations, you made it through Chapter 8. Now it's time to get started with the quiz, essay assignment, and discussion board.